Good afternoon, everyone. Len Gordon at Venable. Thank you for joining us today. I'm joined by my colleagues, Mary Gardner and Mike Munoz. We're going to be talking to you about the recent oral argument in AMG Capital Management versus FTC. It is a time in Washington and at the FTC, obviously, of change. We've got a new acting chair, Rebecca Kelly Slaughter. She may or may not be the permanent selection of President Biden. We've got another commissioner who will be leaving the commission, presumably to go head the CFPB, Commissioner Chopra. And in addition, the power that the FTC has used to go to federal court and obtain equitable monetary relief was the subject of oral argument at the Supreme Court on January 13th. And depending on how the Supreme Court decides that case, the way in which the FTC challenges conduct could change considerably. So with that little bit of introduction, why don't we get started? If you've got questions during the day, during the seminar, put them into the Q&A panel. We will try to get to them. I can't promise you we'll get to all of them, but we will certainly try to get to as many as we can. But put them in as they occur to you, and we'll try and deal with them. Here are your CLE instructions. Pay close attention when my colleague Mary Gardner is speaking. She will give you the secret code word to get your CLE credit. So that's probably the most important thing to listen for today, though I'd like to think everything else we're saying is important too. So why don't we get started? Go to the next slide, please, Mike. Thanks. So we're going to be talking about, the Supreme Court was considering Section 13B of the FTC Act, which was added to the FTC Act as part of the Trans-Alaskan Pipeline Act in the 70s. For the first 70 years or so of the FTC's existence, it brought consumer protection cases in its administrative tribunal in front of an administrative law judge, and it obtained cease and desist orders. And that was, at one point, the FTC had dozens of ALJs, and there's still lots of rooms in the FTC headquarters that used to be hearing rooms where those administrative law judges would sit and hold mini trials, and it would adjudicate whether an advertisement was deceptive or a practice was unfair. In the 70s, Congress, as part of the Trans-Alaskan Pipeline Act, added Section 13B of the Act. The primary purpose was to allow the FTC to go to court to obtain a standstill injunction while the FTC was adjudicating in an administrative proceeding an antitrust case. And this is before the Hart-Scott-Rodino Act, and it was in some ways a precursor to that, and allowing the FTC to have the parties to a deal stand still in a merger until the FTC could conduct an administrative trial that would determine the legality of the merger. But that provision also applies to the FTC's consumer protection mission. And so the slide shows you some of the language of Section 13B, and its purpose is sort of exemplified by the language. It deals with violating or about to violate conduct. And the language that's highlighted at the bottom is what's typically referred to as the second proviso of Section 13B, and it says, provided further that in proper cases the commission may seek, and after proper proof, the court may issue a permanent injunction. And this provision was enacted in the early 70s, and the FTC did little or nothing with it for several years. In fact, until the 80s, it didn't really use this second proviso to seek the kind of broad relief that we now associate with Section 13B. Mike, let me ask you to move to the next slide, please. So as I mentioned, it was added as a stopgap preventative measure, sort of to hold things still until the administrative process could work its way through. 2 years after Section 13B was enacted, Sections 5 and 19 were added to grant the FTC the authority to seek monetary relief for harm to consumers in certain limited circumstances. So let's talk about those circumstances. Mike, can we get the next? All right, so Section 13B, Section 5, we'll start from the basics there. Authorizes the ALJ trials we talked about before and the issuance of a cease and desist order. Section L was added that allows the FTC to go to court, or the Justice Department to go to court on the FTC's behalf to obtain, the language at the bottom is important, mandatory injunctions and such other and further equitable relief as deemed appropriate in the enforcement of such final orders of the Commission. If you look at the language of 13B, it just says injunction. It doesn't have this and such other and further equitable relief language in it. And the presence of that language in this provision of the FTC Act became an important issue at the Supreme Court, as we'll talk about in a minute. Can I get the next slide? So as I mentioned, Section 19 was added in 1975 to provide the FTC with some tools to obtain monetary relief in certain circumstances. There are two primary that we'll talk about today. If the FTC believes someone has violated a rule, the FTC can go directly to federal court to seek relief for the monetary relief for the violations of that rule. And in addition to rules that are promulgated by the FTC, certain statutes, for example, the Restore Online Shoppers Confidence Act that deals with negative option marketing, also has a provision that a violation of it shall be treated as a violation of the rule. So the FTC can use Section 19 of the FTC Act to challenge ROSCA violations. In addition to rule violations, Congress added another provision that supplemented the FTC's toolbox by saying that if a defendant has been the subject of a cease and desist order, they've gone through that process, they've lost, and that order is now final. And just for background, the way it works is there's an ALJ trial. That judge makes a decision, he issues a decision, findings of fact, conclusions of law. That can then be appealed to the commissioners, who act as sort of an intermediate appellate body that can affirm, revise, or overturn the ALJ's decision. And then either the FTC or the respondent can appeal to any circuit court for a review of the FTC's decision. The Section 19 provision that comes here only is triggered when the FTC's ALJ administrative proceeding becomes final. But what Congress did is it gave the FTC a tool that when it challenged conduct under the ALJ proceedings to get money, if the commission could satisfy the court that the act or practice to which the cease and desist order relates is one which a reasonable man would have known under the circumstances was dishonest or fraudulent, the court can grant certain financial relief. Let's talk about what that financial relief could be. Next. So the court shall have jurisdiction to grant relief as it finds necessary to redress injury to consumers resulting from the unfair, deceptive act or practice. So that could include rescission, reformation, the refund of money, return of property, the payment of damages, the public notification respecting the rule violation or other acts or practices. So fairly broad monetary and some other types of relief. But with that ability to get monetary relief in certain circumstances, Congress also imposed certain procedural protections. We already talked about the knowledge requirement necessary to get Section 19 relief, but it also limited it by providing for a 3-year statute of limitations. And as we'll talk about, when the FTC later started using Section 13B to obtain equitable monetary relief, it's always maintained there is no statute of limitations. So this is an important limitation on the FTC's ability. Can we go to the next slide? So in the 1980s, some lawyers at the FTC decided that the process for getting monetary relief under Section 19 was too cumbersome, and that the ability to get an injunction as provided for in Section 13B included not just the ability to get an injunction, not just the specific words that Congress used, but all available equitable relief, which would include certain types of monetary relief, such as restitution, disgorgement. Using the ability to get those tools, the FTC then started seeking asset freezes to preserve its ability to obtain monetary relief. The FTC then started arguing that equitable monetary relief could be imposed not just to disgorge the funds that a particular defendant received, but could be imposed jointly and severally. And several courts of appeals accepted that notion. And over time, the Section 13B route has become the preferred route for the FTC when it seeks to enforce Section 5 of the FTC Act and certain other statutes. The FTC hasn't brought a Section 19 proceeding following on an administrative proceeding probably in 10 or 15 years, maybe longer, and there have been few and far between of those. Section 19's administrative enforcement tool has really withered, and that's an issue that comes up at the Supreme Court, because in trying to figure out what Section 13B provides or doesn't provide, how Section 13B fits into the other parts of the FTC Act becomes an important issue. In trying to take this broad view that it could obtain monetary relief under Section 13B, the FTC relied on two cases that had taken broad views of what a grant of injunctive authority to a government agency or to a court might mean: the Porter versus Warner Holding Company case and the Mitchell versus Robert DeMario jewelry case, that implied that where someone is entitled to an injunction, the court is entitled to award the full panoply of equitable tools, including monetary relief. And these cases were decided when the court took a rather broad view of what remedies might be imposed inferred to remedy a statutory violation. Over time, the Supreme Court's retreated on that view, and if you look at the Megrig case, they refused to find an implied restitutional remedy, and the language there is instructive, where Congress has provided elaborate enforcement provisions for remedying the violation of a federal statute. It cannot be assumed that Congress intended to authorize by implication additional judicial remedies. And the Megrig case was sort of the fulcrum on which one of the cases that ultimately led to the Supreme Court turned. So go to the next slide. And yeah, go ahead, Mike.
Yeah. So kind of as Len mentioned, to follow up on Megreg, and as a precursor to the Supreme Court argument in AMG, the latest Supreme Court case that analyzed implied equitable remedies is Liu versus SEC, which was decided last year. And in lieu, the Securities and Exchange Commission sought and obtained disgorgement under Section 21 of the Securities Act, which provided for equitable relief in federal court. However, before the Supreme Court, Liu argued that because other statutory provisions of the Securities Act expressly enables the SEC to seek disgorgement through administrative proceedings, that prevented the SEC from obtaining disgorgement under Section 21, because Section 21 did not explicitly provide for disgorgement. And in lieu, the court held that disgorgement does fall under an equitable remedy provided by Section 21 of the Securities Act, provided that it only encompasses defendants' net profits of the ill-gotten gains, and that the disgorgement award is returned to investors where feasible. Now, important to AMG, the Liu decision follows MEGREG in that the statute in Liu was more specific in that it explicitly provided for equitable remedies. But Liu also clarified, similar to what Len mentioned earlier, that disgorgement may be punitive in the context of joint and several liability when there's no showing that defendants were partners engaged in concerted wrongdoing. Now, moving towards the FTC context and the cases that lead up to the oral argument in AMG is the Ninth Circuit's decision in AMG. And in that case, it was one of, if not the first, one of the first instances where judges expressed skepticism as to the FTC's 13B authority. In AMG, the FTC sought disgorgement under Section 13B, and the district court awarded the FTC $1.27 billion in disgorgement. And though AMG raised the arguments that where Section 19 provides for such equitable remedies and Section 13B does not, the FTC cannot obtain anything outside of injunctions. The Ninth Circuit relied on its longstanding precedent that the power to order injunctions includes any ancillary remedies to remedy harms resulting from unlawful conduct, and that Ninth Circuit precedent follows the Porter and Mitchell precedent that Len mentioned earlier. However, important here, Judge O'Scanlan, joined by Judge Bea, kind of raised the alarm as to whether this is the correct reading of the statute. Judge O'Scanlan, in his concurring opinion, wrote that though he was bound by the Ninth Circuit precedent, the structure of the FTC Act leads him to believe that Section 13B does not provide for equitable relief beyond injunctions. Judge O'Scanlan pulled no punches in saying that these past errors, even if common, do not justify our continued disregard of the statute's text and the Supreme Court's related precedent, referring to MEGREG, that kind of pulled back the precedent of Porter and Mitchell. And the watershed moment in the FTC's Section 13B authority, is, as far as circuit courts are concerned, didn't come until 2019 when the Seventh Circuit issued its opinion in FTC versus Credit Bureau Center. Now, in Credit Bureau Center, the defendants appealed a restitution award and argued that in light of MEGREG, the court must interpret the structure of the FTC Act to not providing for this type of equitable relief under Section 13B. And the opinion in Credit Bureau Center departed from the Ninth Circuit's decision in AMG because the court found that the textual, structural, and historical arguments so persuasive that it overturned its own precedent in the Seventh Circuit. Judge Sykes, writing for the court, first pointed to the Supreme Court's decision in MEGREG as the intervening circumstance compared to the Seventh Circuit's past precedent to revisit the text of Section 13B itself. In doing so, the court analyzed the distinction between Sections 13B and 19, finding that nothing in the text of the structure of the FTC Act supports an implied right to restitution under Section 13B. The Seventh Circuit panel also pointed out that the reliance on Porter and Mitchell is somewhat flimsy. The statute in Porter provided for injunctions and other orders, and Mitchell expanded Porter, finding that implied remedies are permissible when they fit the statute's purpose. Given the limitations argued in MEGREG, the Seventh Circuit found that the purpose of Section 13B is forward-looking injunction injunctions, which does not comport with the purpose of restitution, which is to remedy past harms. Now, while the parties in AMG were briefing the merits of their case to the Supreme Court, the Third Circuit joined the Seventh Circuit in September of 2020 and held that the FTC is not entitled to disgorgement under Section 13B. In FTC versus AbbVie, the district court ordered defendants to disgorge $448 million for the anti-competitive conduct at issue. Similar to the decision in Credit Bureau Center, the Third Circuit primarily looked to the structure of the FTC Act to find that because Section 5, as Len outlined earlier, allows the FTC to seek equitable relief after it obtains a cease and desist order, and Section 19 provides for the refund of money, Section 13B's silence as to the same indicates that it does not include any such relief. The Third Circuit noted that given the timing of enactment of the provisions of the FTC Act, that is Section 13B in 1973 and Sections 5 and 19, 1975, that Congress had the requisite knowledge to include equitable remedies in Section 13B and chose not to. The Third Circuit also determined that the backward-looking remedy of disgorgement doesn't comport with the forward-looking remedy of injunctions that Section 13B provides. And with that, I'll hand it over to the next section here.
Thanks, Mike. So in the wake of this now circuit split between the Ninth Circuit and at the time, the Seventh Circuit, can you proceed to the next slide, Mike? Both the FTC and AMG Capital Management petitioned the Supreme Court to grant certiorari on the issue of whether Section 13B is the remedies available under Section 13B are limited to injunctive relief, as the Seventh Circuit found, or are more broadly aligned with the Ninth Circuit's vision of also encompassing equitable monetary relief. Initially, the Supreme Court granted cert in both of the cases. But after Justice Barrett was appointed to the court rescinded its grant of certiorari in Credit Bureau, although she was not on the panel that heard the Credit Bureau oral argument. She was at the Seventh Circuit, and we think that that's probably the reason that cert was rescinded. And so the only case before the Supreme Court is the Ninth Circuit's decision in FTC v. AMG Capital Management. Therefore, the question the court was asked to consider is whether Section 13B of the FTC Act, by authorizing injunctions, also authorizes the Commission to demand monetary relief, such as restitution, and if so, the scope of the limits or requirements for such relief. Next slide. AMG Capital, the petitioner in this case, they submitted their brief to the Supreme Court first, and you can really break the petitioner's argument down into two main points: a plain text interpretation argument and an overarching structural argument. So the first argument, plain text. Essentially, the petitioners argue that the FTC's interpretation of Section 13B can't be reconciled with the plain language of the text. As you may recall from when Len started off this webinar, he showed you the plain language of Section 13B. And on its face, the statute affords the FTC the right to obtain a permanent injunction. And the petitioner's argument is basically the word injunction means injunction. It does not mean injunction plus monetary relief. The petitioners also point to another section of the 13B provision that Len pointed out, which is the fact that Section 13B only authorizes the FTC to bring suit where a person, quote, is violating or is about to violate the law. And the petitioners argue that this language plainly indicates that the FTC is authorized to bring suit to prevent future injuries, not to redress past harms. And in the petitioner's mind, traditionally, injunctions have been understood as a form of prospective relief. They're aimed at preventing future injuries, whereas monetary relief like restitution, rescission, disgorgement, those are all forms of retrospective relief that are used to be redress past harms. So, taking those two pieces of language together, the petitioners argue that Section 13B is plainly aimed at preventing future injuries, and so it makes no sense that it would afford the FTC the right to obtain, monetary redress for these past harms. Then the second prong of the petitioner's argument, the structural argument, is that the FTC's interpretation of Section 13B would render the monetary relief provided by other FTC Act provisions superfluous. So the petitioners point to several other provisions of the FTC Act that explicitly afford the FTC the right to obtain monetary relief. And Len talked about these when we did our orientation to Section 13B statutory provisions. But one of them is Section 5L. And interestingly, in the same year that the FTC or that Congress added Section 13B to the FTC's enforcement toolkit, they also amended Section 5L to include that important language that Len pointed you to, which was the expansion of available remedies to include a grant of mandatory injunctions and such other and further equitable relief as they deem appropriate. Similarly, the petitioners point to Section 19, which was added 2 years after Section 13B was Congress added Section 13B to the FTC's toolkit. And as Len pointed out, it affords the FTC the right to seek explicit examples of monetary relief, like rescission, reformation of contracts, refund of money, payment of damages, these types of rewards. And so the petitioners argue that Congress clearly knew how to include a right to monetary relief explicitly in these sections of the FTC Act. And so it would be improper for courts to assume that Congress meant to do so by implication in Section 13B. And that in fact, allowing this monetary relief by implication to move forward would render these other provisions of the FTC Act regarding the FTC's right to obtain monetary relief superfluous. And they also point to the fact that Congress, in passing Sections 19 and 5L, put in place important procedural protections and limitations that are appropriate where the FTC is going to be seeking potentially large figures of money from parties, such as a notice requirement in Section 5L or a statute of limitations in Section 19. And that if the FTC's interpretation of Section 13B is allowed to stand, the limits and protections put in place by Section 19 and Section 5L will be basically rendered null. And then just one third argument that ties back to what Mike was saying about the importance of the Supreme Court's decision in Liu v. SEC. Alternatively, the petitioners argue that if the Supreme Court agrees with the FTC and finds that Section 13B does contemplate equitable monetary relief, the award against the petitioners in this case would still be improper because it does not satisfy the Supreme Court's test for equitable restitution set forth in the Liu decision. Next slide, please. So, in response, the FTC, unsurprisingly, disagreed with most of the statements that petitioners made. And the FTC's argument can be really distilled down into three major points. The first and probably the primary argument for the FTC is that foundational principles of equity and the weight of case law precedent support the FTC's interpretation of Section 13B as providing monetary relief. The FTC, one of the first lines of its argument is that there are 300 years of precedent indicating that a court that has jurisdiction to issue an injunction also has the authority to provide complete equitable relief, which would include restoration of money improperly taken from a party. So, in the FTC's view, any other interpretation of the term injunction other than aligned with injunction plus monetary relief would undermine the foundational principle of equity that a wrongdoer shouldn't be allowed to profit from his or her own wrong. And so the FTC argues that when Congress drafted Section 13B back in the 70s, it did so with the knowledge and understanding of this 300 years of court precedent, holding that a court with the power to enter an injunction may also award other forms of relief, like equitable monetary relief. Secondarily, the FTC argues that Congress has in fact ratified these lower court rulings that Section 13B includes an allowance for equitable monetary relief. The FTC notes that since 1979, 8 courts of appeals have held that judicial authority to enter a permanent injunction includes the authority to require the return of wrongfully obtained funds. Now, that's with the exception of the Seventh Circuit's decision in Credit Bureau and now the Third Circuit's decision in AbbVie, which Mike talked about previously. The FTC says, in the wake of all of those decisions, including decisions from the courts of appeal, Congress has twice substantively amended the FTC Act, once in 1994 and again in 2006. And it's done so without changing the text of Section 13B to explicitly prevent the FTC from obtaining monetary relief in addition to the explicitly granted permanent injunction. The FTC thinks that this is really significant and argues that Congress must have been aware of the weight of this precedent, and it's had these 2 opportunities in which it amended the FTC Act. And the fact that it chose not to alter the text of Section 13B indicates that Congress was both aware of and accepted these courts' construction of Section 13B as affording equitable monetary relief. And then the final point that the FTC makes is kind of a direct rebuttal to the petitioner's structural argument, the argument that these other sections of the FTC Act expressly afford monetary relief, so Section 13B should not. And the FTC says that the petitioners have it wrong, that they are not construing the case law accurately here. Instead, the FTC argues that historically courts have construed statutes that authorize district courts to grant injunctions to also authorize equitable monetary relief unless the statute clearly says otherwise. And here, the FTC says that the petitioners have not demonstrated that any other section of the FTC Act shows that Congress clearly intended not to afford equitable monetary relief as part of Section 13B. They say that specifically, neither Section 19 nor Section 5L support that kind of inference. And the argument that they make is an interesting one. Essentially, they say that prior to the passing of Section 13B in the 1970s, the FTC had one pathway to enforcement, and that was an administrative enforcement pathway. And then in the 1970s, when Section 13B came along, Congress afforded the FTC a new pathway, a judicial enforcement pathway. And these two pathways run parallel to one another. And so the FTC argues that Section 19 and Section 5L provide remedies in that historical administrative enforcement pathway, whereas Section 13B provides remedies in the judicial enforcement pathway. And because these pathways run parallel to one another, the provisions relevant to the administrative enforcement pathway do not have any impact or otherwise alter the provisions in the judicial enforcement pathway. It's an interesting argument, but as you can see, AMG and the FTC are really at odds with each other. And Len's next going to talk about the FTC's or the Supreme Court's themes from the Supreme Court's questioning regarding these very conflicting arguments. Len?
Yep. Thanks, guys. Great job. The argument before the Supreme Court was fascinating on multiple levels. For those who have gone and listened or watched the Supreme Court, it typically, before COVID, it's a bit of a free-for-all. Often several justices dominate the questioning. That was certainly the case when Justice Scalia was on the bench. And sometimes there's interruptions of questioning or answers to questioning. And Mary just really forgot to give you the secret code. So it's AMG 2021. The code is AMG 2021. Sorry, didn't want to screw up and forget that. So anyhow, so it was very, sort of freewheeling. I mean, obviously there's time limits, but it was very freewheeling. Some of the judges frequently don't ask any questions. It had been years since Justice Thomas had asked the question. But in the age of COVID and doing hearings remotely, things need to be more structured. So the oral argument was very structured. The petitioner goes first. They have a couple of minutes uninterrupted, and then each justice, starting with the Chief Justice down to the most junior justice, Justice Barrett, has a couple minutes to ask questions, and then they essentially pass the baton to the next justice, and then it starts with a respondent, and then very brief rebuttal argument by the petitioner. So each justice asks questions, which, and has a time limit. So it's very contrary to the way it normally would work. And I think it makes reading the tea leaves a little bit harder. Normally, you can tell, especially certain justices, exactly what they're thinking by their questioning, the fact that they're asking questions or not asking questions. You can also sometimes sense some eye rolling or, incredulence over arguments. And, it's much harder to pick any of that up in a teleconference. That said, there were some themes that certainly emerged. I think most people thought the FTC had the worst of the argument based on where the judges came out. And one thing that's worth noting is who argued for the FTC. Typically, when the United States is in the Supreme Court, the Office of the Solicitor General argues. On rare occasions, governmental agencies can represent themselves. That most frequently happens when there may be a split between how the agency and the Office of the Solicitor General view the law. Here, the FTC's Deputy General Counsel represented the agency, not the Solicitor General. And, you can infer one of two things: that this case was so important to the FTC that they sought to represent themselves because they thought they could do a better job than the Solicitor General, or the Solicitor General didn't agree with the FTC's position. Given sort of the strict constructionist nature of the Solicitor General's office recently, I tend to think it's the latter, but we'll see. So back to questions. Justices Roberts, Breyer, and Kavanaugh expressed concern about the importance of stare decisis in disturbing this body of law, and that came out during both sides, questioning of both sides. Justice Sotomayor expressed concern that limiting this to an injunction would it didn't really serve the purpose of the statute. Really fascinating questions from Justice Roberts and several others about the standard to apply regarding the inferring of additional remedies. So as we mentioned earlier, the Megrig decision sort of moved the needle a little bit about how easily courts should infer remedies. But that decision was after 1973 when Section 13B was enacted. So the issue the court was wrestling with is, should we apply, in interpreting what Congress meant, sort of the Megrig approach, or the approach that was, the Porter and Mitchell cases that were sort of the law of the land then. And going back and forth, the court seemed to be leaning towards applying the Megrig approach, and those cases can be reconciled. I mean, in either of those sort of regimes, you look at whether the language of the statute indicates that the implied remedy should be implied, whether that's consistent with the purpose and language of the statute. Megrig, I think, makes it a little harder, but it's the same test. So I think the court got through that. Justice Kavanaugh, who's sort of an administrative law junkie, talked about separation of powers and hinted at the concern about administrative creep, where governmental agencies sort of increase their own power, their own jurisdiction incrementally without really authorization from Congress. So let's go to the next slide, please. Justice Breyer was very active. I mean, had hard questions. Justice Alito, Kagan, Gorsuch, and Kavanaugh, all questions about whether the FTC's interpretation of Section 13B rendered Section 19 superfluous. And the FTC I don't think had a great argument there. And part of the problem is the facts show that they've just abandoned using Section 19 for basic Section 5 violations. They very seldom use the administrative process, but they almost never now use Section 19. And if that was sort of what Congress intended, why did they add Section 19 after 2 years after Section 13B? The FTC would talk about the savings provision in Section 19 that says, the adding of this authority doesn't take away any existing authority the FTC had. But the fact that the FTC didn't use this expansive view of Section 13B until after Section 19 was implemented, and the sort of looking at the scheme as a whole, I think rebutted pretty effectively the savings clause argument. And then what was I thought fascinating is that there's an article out there by this guy named Fitzgerald who worked at the FTC and was there when the 13B invigoration took place. And I mean, he wrote that, this happened because Section 19 was too time consuming. And that's obviously the case. And the judges talked about this in oral argument. We had cited that article in some briefs we had filed on these issues earlier, and it was heartwarming to see the court cited as well. Let me go to the next slide. And then Justice Barrett and others follow up on the Liu issues that Mike had mentioned. So, it's important to understand what this really means in the real world. For the last several years, the FTC has said the proper measure of equitable monetary relief is gross revenues, and that can be applied jointly and severally, and that deception supporting such a finding can be found based on only there being deception of a minority of customers. So imagine a situation where somebody sells products in mass market, and the FTC has evidence that a substantial minority of consumers were 20%, 30% were deceived. The FTC would go to court and say, we're entitled to gross sales from all sales, not from that 20%, but from all sales. And we're not only entitled to that from the company, we're entitled to it jointly and severally from the company's officers, perhaps from the company's payment processor, perhaps from their advertising agency. So when you start thinking about it that way, it becomes quite penal. And while that might be good for deterrence, it's not an equitable remedy. And that was the issue in Liu. And I think that's one of the issues that was motivating Justice Barrett. So let me go to the next slide. And Mary, is this you or me?
This is me.
Go ahead.
So in the wake of the Supreme Court's oral argument, a lot of people have been thinking, well, what is the FTC going to do if the Supreme Court, basically knocks down their favored enforcement tool to get monetary relief, and so one of the things we want to cover is, the other tools in the FTC's enforcement toolbox. And some of these Len has talked about in some detail, but one of the options is the FTC could start pursuing, as Len put it, the infrequently used Section 19 action. So they could restart administrative litigation to obtain cease and desist orders. Now, as we've alluded to earlier, there are limitations to administrative litigation under Section 19, which is one of the reasons that the FTC has pivoted so heavily to Section 13B. And one of those is that the FTC can't pursue monetary relief until after it's both obtained the cease and desist order and defended it on an appeal. Second, the FTC has to demonstrate the notice requirement that we've talked about, that a reasonable man would have known under the circumstances that his conduct was dishonest or fraudulent. And finally, there's the 3-year statute of limitations, which does have a limiting impact on the amount of monetary redress the FTC can obtain. Alternatively, the other Section 19 pathway would be the FTC could start to flex its rulemaking muscles more aggressively. And once it's just promulgated rules, it can go directly to federal court and obtain the restitution, redress, reformation of contracts, the damages that it's entitled to under Section 19 for violations of such rules. But again, that proceeding would be subject to a 3-year statute of limitations. Now, another interesting method that the FTC may be able to use going forward, one that Commissioner Chopra has advocated for, is to start to coordinate enforcement activities with other agents who have overlapping enforcement authority. And Commissioner Chopra threw out the example of coordinating with the CFPB on consumer finance enforcement actions. Now, interestingly, many of you may know, President Biden has recently tapped FTC Commissioner Chopra to lead the CFPB. So it's going to be interesting to see just how aggressively the two agencies coordinate going forward. Next slide, please, Mike. Another option would be to refer actions to the DOJ to seek civil penalties. And in that case, the per violation penalty can be all the way up to more than $43,000. So that is a hefty deterrent mechanism. And another enforcement mechanism that Commissioner Chopra has advocated for reviving in the wake of the Section 13B battle is what's called the penalty offense authority provided under Section 5M of the FTC Act. And this authority allows the FTC, rather than the FTC through the Department of Justice, to seek civil penalties directly against a defendant in federal court. It has three main requirements. The FTC has to have first obtained a cease and desist order against another party through the administrative proceeding we've talked about previously. That cease and desist order has to identify a specific practice as unfair or deceptive. And then the FTC has to prove that a party on notice of the order has engaged in the same violating conduct after the order is final. In which case, if all three of those things are true, the FTC can seek civil penalties from that on notice party. So, Mike?
Yeah, thanks, Mary. So in addition to how the FTC may move forward after AMG, whether the court decides in its favor or not, one thing to consider and look at, should the Supreme Court rule in favor of AMG, is how that decision would affect cases currently pending or cases where a judgment has been entered and there's a disgorgement or restitution award under Section 13B. Now, this decision would certainly apply to currently pending cases, as courts are obligated to follow the Supreme Court's directive. But this would also apply to future cases that involve conduct that would predate the decision. The more difficult question is how this would apply to cases where a judgment's already entered. Now here, it may apply to cases that are subject to post-trial motions under Rule 59, which allows the parties to move to alter and amend a judgment within 28 days of it being rendered. But it may also apply to cases that are on appeal where the disgorgement award is directly at issue on appeal. So, for example, if there's other kind of ancillary issues on appeal that might not fall under that. However, the one thing to note is that long entered judgments or judgments no longer on appeal may not be subject to the court's opinion in AMG, as courts are reluctant to reopen judgments that have been long entered and are no longer in dispute. And another potential impact is whether or not a ruling in AMG will affect where the FTC chooses to bring their cases and forum selection. I think Len had a little more to add here.
So it was fascinating because for a long time, one of the FTC's favorite venues was the Northern District of Illinois within the Seventh Circuit. There was a judge there who used to be an FTC staff lawyer. The bench was warm and cuddly towards the FTC. The Chicago office of the FTC filed all their cases there, regardless of where the defendant was. And it was a preferred jurisdiction. Then Credit Bureau came and overturned that apple cart, and you had companies filing declaratory judgments against the FTC seeking to obtain a declaration that the FTC was not entitled to monetary relief. So it was just fascinating the way the FTC's favorite jurisdiction went to its least favorite overnight. the FTC still loves the Ninth Circuit, and the Ninth Circuit so far seems to love the FTC, but we'll see. The Supreme Court may put an end to that. So we'll see. And obviously, however the court rules, there'll be some follow-on litigation interpreting exactly what the ruling means. But the Seventh Circuit issue was really interesting. So we go to the next slide. So what happens if the FTC loses? Earlier this year, in August, after cert was granted, the FTC commissioner submitted testimony requesting that Congress clarify the statutory authority. There was a letter that was on the FTC's website for a day or two asking for that, and then it disappeared mysteriously from the FTC's website, probably because defendants were citing it in cases urging courts not to award equitable monetary relief under Section 13. So, Congress, there has been, in context of a privacy bill or other bills, discussion about fixing the 13B issue, but there's nothing passed yet. It's interesting on the Liu case, the SEC case Mike talked about earlier, jammed into the Defense Authorization Act was a provision that reinstituted some of the disgorgement authority that the SEC may have lost in the Liu decision. It's still, the Liu decision still has impact because there can't be, it still can't be penal in nature, but the requirement that say the money go back to consumers or it's not allowed to obtain disgorgement was certainly softened considerably in the revision to the Defense Authorization Act. So what happens next? We'll have to see. This won't be the end of it. Currently, for those of us who are trying to settle cases with the FTC, whether the FTC is offering an AMG discount, I've been told frequently that that's not the case. I've had some success settling other cases where I'd like to think that there was an AMG discount, or perhaps it was just my eloquence that got us to where we got, but hard to say. And I think it varies a little bit by whether the case is already in litigation or not, and how the FTC views that case. But it's a very interesting and uncertain time. We are just speaking of time. We are out of time. If you've got questions, email any of us. We'll try and get back to you. Thank you for participating today. Let me pull up the code one more time in case you need it. It's AMG 2021. I'd like to thank Mary and Mike who did a great job putting the slides together, and our team who makes all this work smoothly. Hope all of you stay safe and have a great 2021. Thank you very, very much.